Good morning, everyone. My name is Judy Blake, and I am the Leadership and Advocacy Coordinator for Family to Family Network in Houston, Texas. We are an amazing nonprofit that truly strives to empower parents, to educate parents, and we believe that everyone can be successful regardless of disability. I am so happy to have our last session for our spring class. And we have today with us two amazing people that I respect so much and love working with. We have Jeff Miller from Disability Rights Texas, and we have Ginger Mayu from the ARC of Texas. So just a couple of housekeeping notes. If you could, please write your questions in the chat box, and I'll be monitoring that. So some of the questions, if I think that it needs to be asked right away because you just need clarification on something, no problem. If you're a little bit bashful about asking the question to everyone, please don't worry about that because no question is silly. This is probably the 10th time I've heard these presentations, and I learned something new every single time. But if you do feel uncomfortable asking the group, just private message me and I'll ask the question anonymously on your behalf. Please know that this is a very, very safe space. We have parents on the phone, we have community members on the phone, we have self-advocates on this Zoom call. I said on the phone when I meant to say Zoom. And no question is a ridiculous question. So just know that we respect everyone's opinion, and we are all here to learn, to grow, and to share information. So I had sent you all an advocacy documenting form, and I believe you got it either last night or this morning, so please check your email. I will explain what that is right when we come back from our break, after Jeff Miller presents, and I'll explain to you what that is, and I will be needing those back. So please don't be intimidated by the form. Again, no wrong answers. So today we are going to be talking about alternatives to guardianship and supported decision-making. You know, the first time I remember I met Jeff Miller was in Austin on one of my legislative trips there. And we all talk about wanting change. Well, if you want change, you need to connect with legislators. And with Jeff Miller and Ginger Mayu in Austin, they are working so hard to create change in the best way possible for families impacted by disabilities. Jeff works for an extraordinary organization called Disability Rights Texas. And I'm not saying that there should never be guardianship. There are certain cases when it could be appropriate. There's no doubt about it. But what we want families to know is that there are choices, and that is what Jeff is here to talk about. Thank God we live in a free country where we can make choices. And Jeff is going to explain that process. Again, please write your questions in the chat box. And Jeff, thank you so much for being with us on a Saturday. We truly appreciate your time and your expertise. And if you want to go ahead and share your screen, and then you can bring up your PowerPoint, unless you wanted me to do that for you.
No, that.
Okay.
Host disabled.
Oh, I forgot to make you a co-host. Shame on me. Let me go ahead and do that. Let's do that real quick. And Ginger, I will make you a co-host as well. Okay, there you go. So both of you are now co-hosts. There you go.
Can you see my screen?
Yes, we sure can. Thank you so much, Jeff.
So, well, good morning, everyone. And thank you for being here, because I know if you're like me, there are few things you would rather be thinking and talking about early on a Saturday morning than guardianship alternatives. I mean, just wait. You're going to find out. But just real quick before we get into this, but honestly, thank you for being here. This is important stuff. It really is. And like Judy said, at Disability Rights Texas, we don't take the position that no one ever needs a guardian. Because there are cases where people do need a lot of support, and sometimes a guardian is the best way to provide that support. But we also really believe that everyone needs to be able to understand all of the options and all of the tools available, because the guardianship decision is a very, very personal, very, very fact-specific determination that every family has to make for themselves. And so we really believe the more information we can get into the hands of people, the better equipped they are to make those decisions when and if they have to. So that said, just a couple of real quick things about me. I am Jeff Miller. Those of you that know me have heard that I often refer to myself as a recovering attorney, because I was in private practice for a number of years. And now I work primarily at Disability Rights Texas on systemic advocacy issues. So I get to work with our wonderful policymakers and state agency folks to try to improve our systems and programs for folks with disabilities. The other thing that I will let you know now, because you'll probably hear me talk about it as we go through some of this material, I'm also the very proud father of a 20-year-old with IDD. And so when we were talking about self-determination and decision-making and alternatives or to guardianship or guardianship, all those things, not only did I get to help write the laws, I get to live it every day. So that said, let's get into the presentation for this morning. And as you said, if you have questions, put them in the chat box. If you have something that's really important, feel free to go ahead and ask, and let's learn together, because this does work a whole lot better if you let me know questions you have or things that are going on to make this relevant, because this works better as a dialogue than it does me talking for an hour and a half. So let's get started. What I had planned to talk about today is basically the whole idea around guardianship. And that starts with understanding the concept of self-determination, which you're probably familiar with, but we're going to talk a little more just specifically about what it is and why it's important. Then we're going to talk about what guardianship is in theory, and then legally speaking, how does guardianship work in Texas? Because I think it's really important to understand the process of guardianship before we try to understand what are alternatives to guardianship and supported decision-making, and how do all those things relate. I'm going to briefly touch on the guardianship reform movement in Texas and what that has meant to people with disabilities and to the state. And then we're going to look at alternatives to guardianship and supports and services. And that'll become apparent to you why that's important before too long. And then finally, we're going to end by a discussion around supported decision-making. And hopefully you're all familiar with supported decision-making, but if you're not, hopefully you will be by the time we finish today. So those are the things we're going to cover. Hopefully those are the things you thought you were going to hear about this morning, and you're in the right place. So let's get started. Self-determination. When we think about self-determination, I think we've probably all heard the term and the concept. And when I think about self-determination, it's all about understanding people and what makes people people and what makes people happy and what makes people successful and all those things. And it all comes down to choices. It all comes down to making choices in our lives about what impacts us. So, I mean, if you think about it, the simplest definition I know for self-determination is feeling like you have control over your own life. because self-determination is a combination of attitudes and abilities that lead people to set goals for themselves and to take the initiative to reach these goals. So what does that really mean? Well, it means that if I feel like I have control over my life, then I'm much more likely to think about the choices that I make and to plan to make choices and to ask people to help me make choices and to do things because I know that I can make that decision. Whereas if I don't have any control over what happens to me, or someone else is always making decisions for me, then I probably don't spend a whole lot of time thinking about what I want to do next and what my goals are and what I want to be when I grow up and all of those things. Because it doesn't really matter because someone else is going to tell me what to do anyway. And so that's why self-determination is important. And when you think about self-determination, when people really feel like they have control or at least some control over what happens in their lives, then the ideas of self-awareness and assertiveness and creativity and pride and even problem solving and then self-advocacy come into play. Because again, if I feel like I'm in control, then those things come naturally. But if I feel like I don't have any control, then I can, according to research, if I feel like I have no control over what's going on in my life, then I'm apt to feel helpless and hopeless and have discipline problems when I'm young and have all kinds of other problems when I'm older because I just don't care. So that's why self-determination and teaching that to our children and other folks is really important. Although, let's talk about the other side of self-determination, just between parents here. You know, it really sounds great to talk about the fact that we want our children to live self-determined lives, to make their own decisions and to be able to do whatever they want to do and be whatever they want to be. But sometimes, as a parent, there's a little asterisk there and then a footnote at the end of the page that says, I want you to make any choice you want as long as I agree with it. Because as a parent, we love our children and we want to protect them and we want to take care of them. And so the idea of them making a decision that seems not so smart to us gives us pause. And that's when the test of self-determination really comes into play, because this concept of dignity of risk really is part of the whole idea of self-determination. Because if I really, for example, if I really want to believe that my son should have control over his life and be able to make his own choices, then I have to be okay when he makes choices I disagree with. And sometimes that's hard. Now, I will say that besides my son, I also have a 25-year-old daughter who doesn't have a label. But would you believe that my 25-year-old daughter sometimes makes decisions that I don't agree with? It's true. But because she doesn't have a label, I can't go to a court very easily anyway, and say, you should let me make decisions for her because I don't agree with her. However, in too many places, because of my son has a label of ID, there are still places in this state that I can go and say, court, because my son has ID, you should let me make decisions for him. And in some places that still happens, and because the court says yes. Hopefully we've done enough with reforming our guardianship process in Texas, which we'll talk a whole lot about in a minute, that doesn't happen very often anymore, but it still happens. Finally, just research shows us that if people really do live self-determined lives, they're healthier and more independent and more well-adjusted, and they're better able to recognize and resist abuse. And one other thing that's not on this slide, but there's also research that shows that if people really feel like they have a say and feel in control of their lives, they're much more likely to be employed. And that's a really important thing for a lot of us. So hopefully, I know I've said a lot of the same things over and over again, but there's a reason for that. Because self-determination really is at the center of everything else we're going to talk about when we talk about guardianship. Because when we talk about guardianship, we're talking about decisions. And we're talking about who gets to make those decisions. And that is what it's all about. And so as we start talking about the fundamentals of what guardianship means and who's involved with the guardianship process, keep thinking back to, is the individual with a disability more able to express their will and their desires and their wishes through this, or are they less able? And because that's a really important part of all of this. So any questions about well, first of all, Ginger, did you have any comments about self-determination?
Yeah, you're doing great. I was going to say in the beginning, even though Jeff and I technically have two presentations, you can see there's even some ARC logos at the bottom. We work very closely together. So we're going to kind of tag team throughout both presentations. And when I present on legislative updates and advocacy, I'll refer back to some of what Jeff talked about as examples. So we'll make it all kind of connect together. Thanks, Jeff.
And if there's one thing that I could just add, and the group probably knows this, but there's actually a couple of people today that really needed to hear about guardianship and alternatives to guardianship. Most of you know I'm the single parent of a 26-year-old son with autism, IDD, and other disabilities. So I want you to know that that this topic is so important for me, both professionally and personally. And I chose for my son alternatives to guardianship. And Jeff is going to go into what that entails, but I didn't want to have guardianship over him. I want my son to believe in himself, to make his own choices to the extent possible with the right support. And this is certainly a choice that each family has to make for themselves. I just want you to know that this is what I have chosen and it works well for us. And that I understand the challenge in making that personal decision. And like Jeff said, I mean, I don't know about when you all were 26 years old, like my son. I made a lot of really stupid mistakes when I was 26 years old, and I did not have a label. I was just not thinking. So it's just so sad sometimes that when we label someone, we think that's a visa, a passport to take away their rights. So thank you, Jeff.
Oh, no, thank you for sharing. That is powerful stuff. So because, and that actually is a really good segue to what we're going to start talking about next. And that's, before we talk about the mechanics of guardianship and what it, legally what it means, let's talk about some of the ideas. First of all, when we think about guardianship, I think what comes to mind for most of us is guardianship is that process where when someone can't take care of themselves, the court appoints somebody else to do it for them, right? I mean, that's what guardianship is, basically. And guardianship isn't new. Guardianship has been around for a really, really long time in lots of different ways. The guardianship process that we know of in Texas today has been around for over 100 years, and it's a creature of the courts. And we're going to talk a little bit more about that in just a minute. But when you think about the concept of guardianship and why would somebody be seeking guardianship or even contemplating guardianship because like, you know, I just spent 10 minutes telling you that self-determination is the way to go and everybody should have their own right to make their own choices. So why is it that some families even consider guardianship? And there's actually some really rational reasons. A lot of people really think that if they have a child that has significant support needs and they're about to turn 18, you know, the next step, what I'm supposed to do is file for guardianship, because that's just what you do if you have a child with X and they turn 18. Or if you have a child that has this kind of need and they turn 18, it's just assumed. And oftentimes they assume that because that's what they hear from either school districts, and there's lots of school personnel that, despite changes in laws and advocacy over and over and over again, and directions from even from the Texas Education Agency, there's some folks at school that still tell parents, you know, when Johnny turns 18, unless you're a guardian, you're not going to be able to go to the IEP meetings anymore, or make any decisions about their education and all those kinds of things, which just isn't true. But physicians sometimes aren't a whole lot better. There's a lot of physicians that really don't understand self-determination and really don't understand things from the perspective of the individual with a disability. What they think about is a diagnosis and what in theory that means going forward. And it's always been standard practice just to have people get guardianship at 18 because that's what you do. Along with that comes the thought from lots of families, because I hear it from other people, that, well, if I don't get guardianship, then I can't be involved with decisions at school, or I can't be involved with the healthcare decisions of my child. And of course, they're not capable of making decisions for themselves about healthcare or any of these other things. So I need to be guardian. Similar to that is one of the top reasons that families tell us that they consider guardianship is the fear of financial exploitation of their young one with support needs. Because they are really convinced that if they don't have guardianship, that their child is going to go buy a car and open credit cards and have all this debt, and they're going to be responsible for them. First of all, if you find a dealer that will sell an 18-year-old a car with no job and no credit, would you let me know? Because that would be an interesting person to go find. But no, I shouldn't make light of it. Financial exploitation does happen. It is real, and it's a tragic thing. I will just say that people under guardianship get exploited as well. Guardianship is not a panacea to stop that. We're going to talk about some things that can help with that as we go through this morning. But yeah, the fear of financial exploitation is definitely one of the reasons that people cite for looking at guardianship, along with some people believe that if I want my child to get a Medicaid waiver, the only way to do that is to get guardianship, because, or that will give them a leg up. If they have a guardian, then they're almost certain the state's going to give them the Medicaid waiver, and all their supports and services they need will be provided. It would be kind of nice if it worked that way, although in theory, they should give you the Medicaid waiver so you don't need the guardianship, but we'll talk more about that too. And then a lot of people just don't understand that there are other legal ways to provide support to an individual that has those kind of needs without taking away legal rights, which, speaking of.
Well, and Jeff, I'll just go back real quick to the money example, I think, or the money situation. I think you mentioned this earlier, but it always helps me really think about the difference in having a label and not. You know, even if you don't have a disability, kind of as Judy said, when she was 26, she did stuff that probably, you know, made poor choices. I would say most people, as they're turning and becoming an adult or a young adult, have made poor financial decisions, but it's how we end up learning to do better in the future. You know, you get into credit card debt and then you realize that's not something I want to do again. That's how we learn. And so it's not always a bad thing to make a mistake or to fail, kind of back to that dignity of risk. And so I think the money one is just always such a good example of that. I have to point it out again and again.
No, I appreciate that. That is a good example. you can almost say that you learn how to make decisions by making decisions. So the other thing to remember about guardianship, legally speaking, is that guardianship is a process that really does remove an individual's ability to make choices about their life. So it removes people's freedom of choice, their self-determination, and their independence, because that now, at least for some areas of their lives, they are totally dependent on their guardian to decide what's best for them. It also takes away people's civil rights. And we sometimes gloss over that because, well, because of the functioning level of Johnny, he doesn't really understand or realize all those things anyway, is what I hear from certain people, usually people that don't have children that have disabilities, but anyway, but that's the justification is, well, that they don't really understand. So it's okay to go ahead and give the guardian all of their rights and not let them vote or drive a car or get married or any of those kinds of things. So it's just important, not that that's always wrong. Sometimes guardianship really is what's in the best interest of the individual with a disability. It's just important that we realize what we're asking for and what we're thinking about when we make these decisions so that we can make the best decisions possible. The other thing that's really important for families to realize when you talk about guardianship is that when you get guardianship, a guardian is appointed, yes, but a court is in control. Once you get guardianship, you're talking about an ongoing oversight by the court and involvement by the court. So going forward, if any change is wanted to be made in the guardianship as to who's the guardian or anything like that, that requires going back to court and having the court make a decision as to what needs to happen. And guardianship can be expensive. Well, it is expensive. The average cost of a guardianship in Texas is between $3,000 and $7,000. And I don't know about you, but that's not cheap. And it is a big commitment of resources. And so it's something that just needs to be thought about. And it makes it really difficult for some families, even if guardianship might be something that they need to consider and might be appropriate. It's not always something that's realistic. And then we talked about if you want to terminate or modify the guardianship, you've got to go back to court. And then because there's ongoing court oversight, there's also an ongoing responsibility by the family to report to the court what's going on. And we'll talk more about that. Okay. So one of the things that I always like to tell people is, we all know what guardianship is sort of and what it does, but there's actually a legal definition to what guardianship really is. And in Texas, guardianship is a process where the court is trying to determine whether or not someone is incapacitated. In the statutory, what the law says is the definition of a person that's incapacitated is a person that because of a mental or physical condition is unable to manage their financial affairs, care for their physical or mental health, or provide food, clothing, and shelter for themselves. That's really what we're talking about, is someone able to meet their basic needs? If someone is unable to do these things because of their disability, then the law says the court can appoint a guardian to help them in any or all of those areas where they have need. But it's important to remember that that's really what we're talking about. We're talking about the ability to take care of finances, health, and food, clothing, and shelter. That's the big decision for the court. And that's going to come in really important when we talk about alternatives to guardianship in just a minute. Just a couple of other things real quick. When we talk about guardianship, there's really two kinds of guardianships in Texas, or two basic kinds. There's a guardian of the person and a guardian of the estate. the guardian of the person is someone that is responsible for the day-to-day life activities of the individual with the disability. A guardian of the estate is responsible for the financial affairs of the person with a disability. One person can have either a guardian of the person or a guardian of the estate, or they can have both. They can have two separate people, one as the guardian of the person and the guardian of the estate, or you can have one person who is both guardian of the person and estate, to make it even more confusing. And then there is a process. In certain circumstances, the court can appoint a temporary guardian to make decisions for limited amounts of time in specific circumstances. The last thing I'll say just about types of guardianship is that the law says that guardianships should be as limited as possible, especially after guardianship reform. So the court should be making a determination as to which areas in a person's life that they actually do need that additional support of a guardian in, and not just blanketly determine that because someone has a need to have someone help them with their finances, they should lose all of their other civil rights as well. It doesn't always work that way, but that's the way it's supposed to work, is the court looking at how to keep the guardianship as limited as possible. Any questions over just the general ideas of guardianship and the different types and that sort of stuff?
Yes, I have a question. I guess my question is, I know you mentioned like one person, but for instance, for an individual, like you said, there's a state and then the guardianship, can you have more than one person, like request guardianship?
And by accident, Jeff, I muted you. My apologies. I'm sorry, I didn't mean to do that.
Very good question. And I should have mentioned this. In Texas, only one person can be appointed a guardianship at any one time, except for the one circumstance that's different is a married couple, parents of a child with disabilities or in need of a guardian can be appointed as co-guardians. But that's the only instance where you can have two people at one time that would be appointed guardian. But good question.
And you said they have to be married. So two parents who are divorced cannot be.
Would not be appointed.
It's an interesting distinction.
Does that make sense, Leonella? Did that answer your question?
Yes, thank you.
Great question.
Any other? So let's talk about how this process works and how fun it is. So generally speaking, so if a family that is considering guardianship for a child, first thing you do is you find an attorney, because in almost every county in Texas, in order to file for a guardianship, you've got to have an attorney do it or do it under the supervision of an attorney. And so that's where things start. And that is one of the reasons that guardianship is so expensive, is that you have attorneys involved. And so it just, the way it is what it is. So once you hire the attorney then files an application for guardianship with the court that handles guardianships in the county where the individual with the disability lives. So that's where guardianship gets filed. In some counties, the larger counties in Texas, so in Houston and Dallas and Fort Worth and Austin and San Antonio and El Paso, there are specialized courts called probate courts that handle only wills and trusts and all those kinds of fun things, and guardianship. So those are specialized courts with judges that understand those issues and deal with those issues solely. In the rest of the state, in the other counties, guardianship is handled by the constitutional court at law. So that the general county court in that county would handle guardianship along with people that are suing each other and divorces and all those other wonderful things. So it makes guardianship kind of interesting. So you file the application in court. Along with that application, there's a evaluation from a medical professional that has to be filed. It's called a Certificate of Medical Examination, or a CME. And that CME is done by either a medical doctor, an MD, or if you're talking about a situation where the individual with a disability has an ID, then a licensed clinical psychologist can do the evaluation, which is probably more appropriate anyway. And so that report is supposed to tell the court what is the ability to make decisions and communicate and all those sorts of things of the individual with the disability. The report is also supposed to give the court an idea of what's the likelihood that the ability to make decisions or choices and to do these things is going to change over time. Meaning, is there a reason for the court to set a specific review date in 6 months or a year or whatever because the medical professional believes that things are going to change? So that's in this report. It's filed with the court. When that's filed, the court then appoints an attorney ad litem to represent the interests of the individual with the disability. The attorney ad litem is the attorney for the individual with the disability. Their role is to look at the situation, meet with the individual with the disability if that's appropriate, and try to determine what it is that the individual with the disability wants. Do they want to have a guardian? Do they think that they need help making decisions? If they need help making decisions, what kind of help do they like or do they need? If they think that they need a guardian, who is it that they want to be their guardian? Is there someone they really don't want to be their guardian? I mean, those are the kinds of things that an attorney ad litem would be looking for. The court also will probably appoint either a guardian ad litem or a court investigator to look at the situation. The guardian ad litem's role is to meet with all the parties, review all the records, and try to make a determination of what's in the best interest of the individual with the disability. Just all things being equal, what would be best for them, not necessarily what they want, but what they think would be best. So that information all gets communicated to the court. Then there's a hearing. At that hearing, you can call witnesses and present evidence. The person with the disability may or may not be present depending on the situation. And finally, after the hearing, the court makes a determination. First, the court determines whether, based on the evidence, it's the person with the disability is incapacitated. If they determine that the person is incapacitated, the court will then determine what rights the individual with a disability retains, if any, and what rights will go to the guardian to execute. Once that determination is made, then the court decides on who to appoint as guardian. One thing that I do tell parents about is, in most cases, 99% plus probably, the court is going to appoint as guardian the person that filed the application, unless they're disqualified by law and they're not a legal resident, or they've been convicted of certain felonies or those sorts of things. Those would be reasons that they would be disqualified by law. Technically, that should have, if that's the case, then the application shouldn't have gotten this far anyway. But it is up to the court to decide who to appoint as guardian. And sometimes the court can appoint somebody that we didn't expect. And that can be unsettling for families, but courts can do whatever they want because they're courts. So just a word of caution. Once the guardian is appointed, then the guardian has to file a bond and then has to complete all of the duties of a guardian, which includes, and we'll talk about in a minute here, there's an annual report the guardian has to fill out and that sort of thing. So actually, before we get into the rest of this minutia, because we're probably going to skip some of that anyway because of time, questions about the process of guardianship? And I know I'm doing a
Yes.
great job of explaining things, but if you have even a little question.
Oh, no, you're doing great. So a parent wrote, what happens if a parent has guardianship for their adult child and the parent passes? What happens to the adult with the disability? And that's a great question.
That is a great question. So what happens is if the guardian, for whatever reason, is no longer able to fill the role of guardian, then somebody has to inform the court and go back to court and make a motion for the court to appoint somebody else as a successor guardian. While it's possible to designate, if you're the guardian, designate who you would like to be the successor guardian so that the court knows that, there is no way in advance to have a successor guardian in place, meaning that if the original guardian is no longer able to serve because of health or they pass away or whatever, that it just automatically moves. Once the original guardian is no longer there, then a person has to go back to court to get a successor guardian. One interesting aspect of this is we have actually seen cases where individuals have guardians and end up in ICFs or other places, and the guardian has passed away, but nobody ever went back to court to get a successor guardian. So you have a situation where an individual is under guardianship, meaning that they are unable to make a lot of their own decisions to contract or all of those kinds of things, and really make their own health decisions and whatever, but they don't have a guardian. And so there's no one that can make those decisions legally. Now, in the real world, people often get by and do things, but legally speaking, until somebody goes back to court and has somebody else appointed, there's no one legally able to make those decisions. So, interesting question.
And if I could just add, there's a family that I've known basically since the little boy was, I don't know, probably 4 or 5, and he's now 25. The grandparents are co-guardians. And we're seeing a lot of that now, where parents are out of the picture for various reasons. And so the grandparents are co-guardians. Mom lives out of state. And the young man, they have authorized me, not obviously to be a co-guardian, but I'm kind of the grandparents can't be reached. He's in a group facility. The group facility, I've established contact with them. We've had meetings. They know to contact me. So, you know, there's always ways. It's called, as we've talked about in each class, building that circle of support. And we all need a circle of support, regardless of disability. Leonella, you raised your hand. Go ahead.
I wanted to ask, what happens in a case, like, let's first say somebody has guardianship over a person, but you feel that person is not adequate to have guardianship over that person, or is not making the right decisions for that person, and you want to take over or take action?
If in a situation where anyone has reason to believe that the guardian is either not fulfilling their legal responsibilities, or which include, or is not taking into account the wishes of the person under guardianship, because that's what a guardian is supposed to do. The law says that anybody can contact the court. And so often with a letter or an email, someone contacts the court and says, I have reason to believe this guardian isn't fulfilling their job or isn't doing things in the best interest of the individual, whatever. Then the court has an obligation at that point to investigate and determine if there is reason to look at appointing another guardian or that sort of thing. So that's one way to handle things. The other way is that if someone really believes that the guardian that's been appointed isn't the right guardian and they would make a better guardian for the individual, you have a right to go directly to court and to ask to be appointed as guardian, to have the other guardian moved out of the way so that you can be appointed guardian. That doesn't happen a whole lot, but it is possible, and it does happen at times. Does that answer the question?
Yes, thank you.
So just real quickly, as a guardian of the person, I fill out this report on an annual basis. It's filed with the court. And the reason that this report exists is the court has oversight responsibilities of people under guardianship, meaning the court's ultimately responsible. So if something bad goes wrong or goes bad with this guardianship, technically it's the court that's responsible for that. So on a regular basis, on an annual basis, this status report's filed with the court so they know where the person's living, what they're doing, are they working, are they volunteering, what is their financial situation, what's their health like, all of those things, so that the court can then determine whether or not they need to do more investigation about something or have a hearing about something or whatever. But that's why that report is important. One thing to know about that report is that if the guardian does not file the annual report, that is grounds for the court to remove the guardian. So once again, doesn't happen a whole lot, but it does happen. And so if you're a guardian, please file your reports on time. If you're a guardian of the estate, you have a lot of the same kinds of responsibilities, but you also have a whole added layer of doing an inventory of all the assets on an annual basis and filing an investment plan and working with a monthly allowance if that's part of the process. So it's a lot more complicated to be a guardian of the estate. And so attorneys are usually involved when you're talking about reporting around guardians of the estate, and accountants, just to make sure that everything is done the right way. So that is the guardianship process in Texas. Hopefully you got a flavor for the fact that there's a lot going on there. When we talk about guardianship, it's complicated, it's complex. The answers to most questions are it depends. And so it's not really a very family-friendly process. We've also talked about the fact that guardianship can be very expensive for some people, and well, for all of us, but guardianship is expensive. Guardianship takes away the rights of individuals with disabilities, first and foremost. So the reason I bring those things up is that those were some of the things that a group of us were talking about a few years ago when we were looking at the guardianship process in Texas. And we were looking at all of these problems with the process and tried to figure out what could we do? How do we make things better? And so this group gets together and starts meeting, and it's a group that has family members of adults under guardianship and advocates and probate attorneys or attorneys that practice in guardianship and a probate judge and people from the mental health community and people from the aging community all got together and started talking about what do we do? How do we make this system work better for everybody? Most importantly, the person with the disability, but for all the players involved. And so this group that called itself the Guardianship Reform and Supported Decision-Making Work Group starts meeting, comes up with a series of proposals. These are then presented to the state Supreme Court's working interdisciplinary committee on guardianship stakeholders or wings or whatever. The Court Office of Court Administration signs off on it, and eventually these proposals to change things in the guardianship process in Texas become proposed laws that in 2015 are enacted by the legislature, which is a great story of the kind of thing where a group of people said there ought to be a law, or there, in this case, there ought to be a better law, and got together and actually 2 years later actually saw things change. I won't promise you that happens every time you come up with a good idea that things ought to change, but it does just go to show that sometimes all the cosmic tumblers click into place and something good can happen if we just stick at it and work at it. But when I think about guardianship reform in Texas, what's really, really important to realize is that along with the concept of self-determination in Texas, our guardianship reform process is all based on the idea of person-centered thinking. And I'm guessing that you all have covered the ideas of person-centered planning or person-centered thinking, but just to refresh and remind, the whole idea behind person-centered thinking is to stop looking at individuals as labels or as things that need to be fixed or made better, and start seeing people as people. The whole concept behind person-centered planning or person-centered thinking is understanding the strengths and the values and the gifts of individuals, along with this identifying the support needs that they have in order to live the self-determined lives that they want, and figuring out a way to meet those support needs. And when we think about person-centered thought, I mean, the core concepts, and we're just talking, scratching the surface here, but basically the idea is that when you think about person-centered thinking, the core concept is things that are important to a person and things that are important for a person. Thinking not only about those things that are important for someone, like health and safety issues of physical health and emotional health and all those sorts of things, and finances, being able to support themselves and where a person lives. All those things are really important, and they're important for all of us, and all of us need a plan to deal with those things. Sometimes when we're talking about people that have significant support needs, this is all we think about, is what's important for them in order to live. What we miss oftentimes are those things that are important to an individual. Who do they want to be around? Where do they want to live? Where do they want to work or volunteer, or do they want to? What kinds of, even down to what kind of pictures do they want on their wall in their room? All of those things really are important, and they're important to all of us. So we should remember they're going to be important to individuals that have support needs as well. And so the whole idea behind person-centered thinking or person-centered planning is to come up with a way to, not only are we looking at the person as a person, so we are identifying those specific support needs that the individual has, and then we're going to find a way to meet that need. This can be done lots of different ways. The classic way when we think about person-centered planning is getting together that circle of support that Judy was talking about, of interested family members and friends and service providers and other people that are involved in this person's life, and having that conversation of what is important to them, what is important for them, what are their goals over long-term, short-term kind of stuff, and then coming up with a plan to meet those goals. And that concept is really important when we talk about guardianship reform in Texas, and we'll get to that in just a second.
Thank you. Yeah, that's great. And just so you know, and I know you've got more to talk about, we did discuss important to and important for, and person-centered thinking and person-centered planning. Laura Buckner. Yeah.
I should just put Laura's picture there and going on.
There you go. That's okay. But you know what? It helps to hear it again and again, because that concept of important to and important for is critical. And I think the more it's explained, the better.
Thanks.
And it's important to remember it in the, to remember that when talking about the framework of guardianship. I think sometimes people forget that even if guardianship is the best option for your loved one, that doesn't mean they lose the right to have person-centered thinking or to have things that are important too. And I think that is sometimes forgotten. We see them separate and they really go hand in hand.
Absolutely, Ginger.
If you do it the right way. So ultimately, out of all of these discussions around guardianship reform in 2015, the legislature enacted 3 different laws based on the proposals from the GRSDM group. They passed a law around alternatives to guardianship. They passed the Supported Decision-Making Agreement Act, which we're going to talk about in a minute. And then they also passed a Bill of Rights for people under guardianship. And that was done because the group really believed that, number one, there are lots of people that are already under guardianship, and there are some people that we know in the future will be under guardianship. And there are certain rights that are just so fundamental to being a human and to being an American citizen and a Texan that you don't lose them even when you're under guardianship. And those are things like the right to be treated with dignity and respect, the right to see your guardianship order, the right to talk to your guardian, the right to have friends and be able to communicate with them. I mean, we're just talking about basic fundamental things. And the scary thing that I would just point out is the reason that we thought all these rights needed to be put in one place in one section of the estates code so everybody could see them is that in lots of cases, people weren't paying attention to those rights of individuals under guardianship. Which is a sad commentary, but it's true. And so, you know, there weren't a lot of new rights created with that Bill of Rights, but it does go a long way to setting all those things out. And it gives advocates and attorneys something to point to when they're trying to get a court to determine that a guardian isn't doing the right thing by their the person under guardianship, and there needs to be a change or that sort of thing. So for what it's worth, so the number one biggest thing that came out of guardianship reform is this. The Texas legislature has now mandated that before a court can determine that someone is incapacitated and needs a guardianship, the court has to examine whether alternatives to guardianship and supports and services that may be available to the individual have been considered and whether or not those would work. If the court finds that those have been considered and found to be that they don't work, then the court can find someone incapacitated and can appoint a guardian. If the court finds that they haven't been tried and no one has looked at those things, then it is inappropriate to appoint a guardian in that situation. And so what it really means is that if someone is able to do those things we talked about that are the definition of incapacity, take care of their food, clothing, and shelter, their health, and their finances with help, but they have someone in place to help them, then they don't need a guardian. And that seems really simple and like common sense, but that isn't the way the law was before 2015. There was no standard for the court to look at or directive that they had to make this finding that alternatives and supports and services don't work. And it also gives a standard for people that disagree with being placed under guardianship. This is a real standard that can be appealed, and it gives grounds for attorneys to appeal something. So this really is a paradigm shift for guardianship in Texas. Just quickly, a couple other things about the bills that were passed in 2015. One of them, the Supported Decision-Making Agreement Act, made Texas the first state in the country to put supported decision-making into statute. So yay, Texas, we did something right for once where it's actually nice to be, or we can be proud to be number one about. How's that? And I talked about
one of the very few things, right, when it comes to disability.
And I talked about the Bill of Rights. So,
Jeff, can I go back real quick?
Sure.
Here. No, good. You're good. I think it's important to recognize since guardianship reform started in Texas, I get calls from people all the time saying, I was told I need to get guardianship of, my loved one. How do I do that? Blah, blah, blah. And a lot of times when I start talking to them about, well, tell me a little bit about why you feel your child, it's usually someone's child, needs guardianship. Well, and usually it's kind of like what Jeff talked about earlier. Oh, the school told me I had to, or, somebody told me I had to. And then I'll say, well, what kind of supports does this person need? And you start talking about it, and then you start outlining alternatives. And I would say 90% of the time, the person I'm talking to is like, oh, I had no idea that was an option. I would totally rather do that. And so I think this is such a good thing for the individual for sure, because we shouldn't remove someone's rights unless that's really needed. But a lot of times the parents don't realize what their options are. And so, and then I'm sure Jeff probably said this, I might have missed it, but if you try an alternative and then realize it's not working, you can always then decide that you need to either try a different alternative or partial guardianship or full guardianship. Once you get full guardianship, it is a lot harder to then take that back and try an alternative. So it's always better to try the alternative first. And I really do feel like 90% of the time, the parent is like, nobody ever told me about all these other options. Thank you.
Exactly right. And I just flipped ahead here because I think seeing the continuum idea makes sense to me, that when we're talking about alternatives to guardianship and supports and services, they're on one end and a full guardianship's on the other. And there's lots of room in between, depending on what you're talking about in terms of an alternative to guardianship or a limited guardianship or whatever. It doesn't have to be all or nothing. I guess that's the one thing. And then Ginger's exactly right. It always makes sense to start with the least invasive, less expensive alternatives. You haven't lost anything if those don't work out. But if you spend $7,000 and you have a guardianship and a year later you realize Johnny really doesn't need that level of support, they're just fine with their Medicaid waiver and living here with me, so why did I take away all those rights? Then you have to decide, is it really worth it to spend the thousands of dollars it's going to take to go back to court and try to fix it? And then there's no guarantees. So for what it's worth. So just quickly, so we can get through the rest of this in the time that we have. So the legislature has now said, court, you have to look at whether alternatives to guardianship and supports and services have been considered. When we talk about alternatives to guardianship, we're talking about legal documents that give another person the right to make decisions on our behalf. Some of these things you've heard of, I'm sure, or about, some of them maybe not. But when we talk about alternatives to guardianship, we're talking about things like a medical power of attorney is one of the most common alternatives that we talk to folks about. And a medical power of attorney is just what it sounds like. We're probably all aware that a power of attorney is a way for me to allow someone else to act on my behalf. So it's me giving the authority to someone else to make a decision for me, and a medical power of attorney gives me the right to have somebody else make medical decisions for me. And so it basically says, if I'm in a situation where I'm unable to make my own medical decisions, this person can do it for me. A durable power of attorney is a similar concept. It's me giving someone else to make decisions for me or act on my behalf. A durable power of attorney, what the durable part actually means that if I enter into a power of attorney with somebody else to take care of my finances or make decisions for for some other reason, educational decisions or whatever, if at some point in time I become incapacitated, the durable power of attorney will stay in effect until a court determines otherwise. So it's something that can be used, especially if you have someone that has a chronic condition that's likely to get worse, or you're dealing with dementia or those sorts of things. It's a way that when someone still has capacity, they can try to give someone else the power to take care of things if they think that there's a chance they might no longer be able to do that. Similar to that is things like a declaration for mental health treatment, which is a way I can say in advance, because I've had a history of, or I'm afraid that there's going to be some kind of mental health situation. It lets me determine in advance what kinds of treatments I want, or what kind of treatment I wouldn't want to have, certain drugs or electroshock or those sorts of things. So some of the other alternatives, remember we talked about the fact that financial exploitation, or the fear of it, is one of the reasons that people look a lot at guardianship. So there are some things that can be put in place to help someone that we fear might be taken advantage of with their finances. Things like the representative payee program through SSA, and the VA, actually, they both have a program that allows someone else to be appointed to receive the Social Security funds on behalf of the individual with a disability. So that happens, or that can happen. Things as simple as a joint bank account, and I talk about this all the time. The traditional idea of the joint bank account, if we're worried about our loved one not being able to handle their finances or whatever, you put the money in a joint account. It takes both signatures to get the money out, and so it gives you some kind of protection. And that's true. And in some cases, that's totally appropriate. In a situation like with my son and I, we don't have a joint bank account. My son has his own bank account because he has his own job, but I have access to his account so that I can periodically just monitor what's going on. And if I see something that looks really weird, then we have a conversation. Sometimes it's just a matter of trying to figure out, what would work. And with all of these, when we're talking about alternatives to guardianship, we're not looking for one silver bullet that's just like guardianship, but not, because there isn't anything like that. Because guardianship is, a drastic take over everything kind of a thing. When we talk about alternatives to guardianship and supports and services, go back to the person-centered thinking model, where we are looking at what is the specific need that we've identified, and how can this alternative or this support, how can those things meet that specific need? So if we're dealing, with finances, or somebody being able to be protected with their finances, a joint bank account or something similar is a way to fill that need, as is a special needs trust. We know that if somebody is receiving SSI, there's a limit on the amount of assets that they can own, or they start losing that eligibility for SSI, and as a result can lose Medicaid. And for most people that have support needs, that's not a good thing. So one way to protect an individual so that we can leave money for the benefit of an individual that has a disability and gets SSI is to leave money in a special needs trust, because this is a way to save money on behalf of somebody else. And a special needs trust is a special kind of trust that shields that money from being considered by the IRS and Social Security when they're looking at those assets. And if you don't know about or want more information about special needs trusts, I would suggest a very good place to start is the ARC of Texas, because I've heard that there's a trust thing going on over there. But
well, thank you, Jeff. And I was going to say, even if you are the guardian of someone with a disability, a special needs trust can still be important. It can be an alternative to guardianship. It can be an addition to guardianship, because it is complex for anyone, disability or not. And I'll go ahead and put in the chat the contact information for the ARC of Texas's Master Pool Trust program. I will say that Haley Greer is fantastic.
She is.
And if you need to talk to someone about a special needs trust, she's not going to just say you should be part of the ARC's Master Pool Trust. She's going to give you all of the options and help you make the decision that's best for you, whether it is the Master Pool Trust through the ARC, a different trust, or an ABLE account, or a combination. So,
yeah. And she actually talks to people like people, not like an attorney. So that's a real plus.
You're doing great as an attorney and talking to people.
So let's talk, when we talk about supports and services in this context, what do we mean? Well, supports and services are formal and informal resources and assistance that help people to meet their need for food, clothing, and shelter, care for their health and their financial affairs. So those things we talked about when we're looking at incapacity, and also specific to helping someone make decisions about where they live, if they vote, if they drive, and if they get married, because those were rights that we just routinely saw were taken away probably prematurely by lots and lots of courts. So those were important when the legislature was considering this stuff. So when we think about supports and services, remember, again, it's figuring out what's the specific need this individual has and how do we meet those needs. So there's lots of different ways to meet lots of different needs depending on what the need is. And so when we think about supports and services, there's not usually one comprehensive list because it could be lots and lots of stuff. The trick here goes back to that person-centered planning idea of identifying the need and then getting creative and trying to find out in my community, what is there that could help meet this need? So some things are common everywhere, like if you're lucky enough to have supported family and friends, that is a support that most of us have in some way or another and is really important. Unfortunately, not everybody has supportive family and friends, and not everybody's family and friends are in a position to provide all the support that they need. So what other kinds of things can we consider when we think about this? Well, one of the things, the Medicaid waivers are wonderful supports for lots of people. The only problem with Medicaid waivers in Texas is that you need to pretty much know about 15 years before you're going to need that support, that you need that support. So that's not always an answer for everybody in the short term. Things like case management services, whether through Medicaid or other programs, just to help coordinate things in a person's life can make a big difference. Person-centered planning, which we talked about, and then just looking and knowing the resources in my community. Is there some local or regionally based program that provides reduced or free food for people, or prescription drugs, or deliveries of those things? Or are there transportation programs that I can get involved in? Or are there, I mean, if we're worried about someone being isolated and not following through on things they're supposed to do, there's visitation programs or daily calling programs. Technology has allowed us just to do lots and lots of stuff. So I'm not going to go through all of these, but I think it just helps you to see that when you think of supports and services, when we're talking about alternatives to guardianship, the sky's the limit. It can be whatever it is we can figure out will help that individual meet that specific need in their lives. And I know I sound like a broken record because I keep going back to specific need and specific way to meet the need, but that's what it's all about. And if we think about things that way, there really are, in most instances, ways aside from guardianship that we can help people live the lives that they want to live. So that is guardianship, alternatives, and supports and services. Thoughts, questions?
Jeff, thank you so much. That was great. And I just want to add that when I opened up a bank account for my son, that he has what they call just an ATM card, because I did not want him to have just a debit card where if it got in the wrong hands, anybody could use it.
Yep.
So it can only be used at an ATM machine. And why is that important? Because there's always a camera at an ATM machine. Now, granted, a person could hide their face and put their face low, but at least there's some way, some safeguard, if you will. So, and another thing I want to mention too is, and this is for the parents on this call, just because your loved one doesn't drive doesn't mean they shouldn't have some form of identification. Make sure that you get a state ID. And they now have on state IDs where you can put on the back communication impediment, and you can have that for driver's licenses as well. So all of these little things, when you add them up together, allow people with disabilities to lead those self-determined lives. Leonella.
I mean, my question.
No, we love questions.
Absolutely.
It's great.
I know you mentioned like some individuals who have guardianship, like their parents have passed. And I guess my question would be, how do you protect someone against guardianship? And the reason I ask that question is, for example, like nowadays you do hear like facilities or stuff, they gain guardianship over a person and they take advantage of their financial access and everything. As a parent, I think that's a major concern for a lot of parents, especially if you only have one child and they don't have siblings. How do you protect them against that when you're gone? Is there anything you can do for someone to, because I know we have these laws in place, but unfortunately, there are individuals who don't have the capacity to really acknowledge what that's for or what it is.
Well, good question. And unfortunately, it's one of those questions that there's no simple answer to. The kinds of things you can think of if we want to protect someone from being taken advantage of when we're no longer around to be guardian or whatever. One way to do that is to think in advance. If I'm no longer here to be guardian, who is someone that I know that the person under guardianship knows and would want to play that role in their lives? And there's an alternative to guardianship called a designation of guardian before the need arises that allows me to designate if and when I need a guardian at all, or maybe another guardian, this is the person that I want to be appointed. Now, the court doesn't have to honor that, but they generally do unless there's a reason not to. So that's definitely one way to think about it. Secondly, if a private guardian or another guardian is appointed, like we talked about before, and we have reason to believe that they're not acting in the best interest of the individual with a disability, that is when a letter is written to the court, or we go to the court and we explain, and we don't have to have proof that something awful is happening. A real suspicion that's done in good faith and that relayed to the court can make a big difference. And you can actually report it anonymously. So that's another safeguard that is in place. The other thing is just looking at the individual with a disability and working with them and seeing if they had a guardian, but the new guardian isn't doing what they need to be, is guardianship still appropriate, or is there reason to believe that we should look at restoration of all or some of their rights? And just by the way, if you ever know anyone that is under guardianship would like to talk about having some or all of their rights restored, that is something that we do at Disability Rights Texas, and I'm always interested in talking with people under guardianship about those issues. So enough of my commercial, but
that's great. Does that answer your question, Leonella?
Yes.
Okay. And I just want to add to that. Again, I know I share a lot of personal stories, but I think that's one of the ways I can connect with families. So for example, my son As I mentioned, we opted for supported decision-making. His dad and I have been divorced for over 20 years. Ryan is 26, and his dad moved to Florida many years ago. So God forbid something should happen to me. Would Ryan be able to live on his own? No, it's just not a good thing. Does he drive? No, you're welcome. Not a good idea there either. So I have in my will of a dear friend who he knows and loves, and she would take care of him. So those are steps that I've taken. Now, have I talked to his dad about that? Of course I have. So would he probably go for that? Probably, because you don't want to uproot somebody from their total surroundings and all that they've known their entire life. So it's just, these are things that we have to be thinking about because we never know when that day is going to come. And it is so important to have a plan in place. So these conversations are difficult.
Ooh, very.
They're very difficult to have, but they are so important. Because if I could tell you the number of families that call Family to Family Network, oh my gosh, the parents died, we can't find any documents, we don't know what's in place. Oh my gosh, you know, my husband passed away, he took care of everything. Or my wife passed away, she took care of everything. I don't even know if they've been evaluated. I don't even know who the doctors are. So that's really, really important to have. I have a fireproof, waterproof box that's in my bedroom. And everybody knows, go to the box, because that's what has everything that's needed. So Jeff, I can't thank you enough. We're going to take.
And Judy, I'm also going to put in the chat here something from the ARC of the U.S. has the Center for Future Planning.
Okay.
And it's a great resource of things that probably are in your fireproof, waterproof box.
Yes.
And what people should have lined up.
Absolutely.
And they even walk people through the process of planning. So
perfect.
I went ahead and dumped that in chat.
Thank you.
For everybody.
Thank you. Thank you. So I know that that a couple of you, I know some people have joined us, some people might have to leave. So I put in the chat box the survey. The more we know, the more we grow. And we're always learning. So at 9:29 a.m., if you scroll up in the chat box, I put the SurveyMonkey link. Please make sure that you complete that if you have to leave. If you're going to be staying with us, wonderful, because we have a great, great topic coming up. And is this where you wanted to take the break, Ginger?
Well, I was gonna briefly talk about supported decision making.
Please.
Then we were gonna take
my bad. Go ahead and do that.
Yeah, I mean, we can do it either way. I just wanted to make sure, and we're not going to spend a lot of time on this, but supported decision making, I guess the first question I have, somebody, and to put everybody on the spot, who has heard of supported decision making? I was going to ask it the other way, but I'm not going to call out.
You can either write it in the chat or raise your hand.
Raise your hands for me, folks. Let me see. Okay.
Okay, the fact that only 3 of us, and one's me and one's Judy,
yeah, so then
really, really excited that we're doing this, Jeff, or you're doing this.
So supported decision making, first of all, we talked about earlier, Texas was the first state in the nation to put it in state statute. Yay for us. We're all good. But what is it? Well, supported decision making, and there's a legal definition and all that stuff, and we're going to talk about the mechanics in just a second. But supported decision making is really, it's not new. Supported decision making has been around for a long time. We just didn't call it that, because supported decision making is a way for an individual with a disability to agree with somebody else to help them make specific decisions in their lives. And in, forever, the way this has been done is a family member or a friend of someone that has support needs, just either formally or most times informally, just take care of each other. And it's done through just communicating together. And I know whenever I have a question about X, I'm going to call Joe and he's going to help me. I mean, and if you think about it, most of us use supported decision-making in our own lives, because whenever we make big decisions in our lives, especially, sometimes small decisions too, but especially big decisions, we typically talk to friends or family about decisions we're thinking about making before we make them. So before we buy a new car, before we buy a house, before we get a new phone, we typically talk to other people and get their opinion, and we use that to inform our decision. That is supported decision-making. And we've already talked about decisions, but just I will throw this in again. The whole idea behind supported decision-making is that decision-making is a right that we have based on constitutional rights with the US Constitution and the Constitution of the state of Texas. So that's why there's all these rules in place around guardianship, is that there really are due process protections that we have because of the constitutional rights that everybody has once they turn 18. But the other thing, just to remember still again, is that our rights should not be dependent on us making decisions that other people agree with. So back to that dignity of risk kind of thing. So supported decision-making is a way that an individual with a disability can get the assistance to make decisions about their lives that are really important, short of having to give up their rights through something like guardianship. And I'm having trouble there. So a supported decision-making agreement is what we have formalized in Texas. And the whole concept of supported decision-making is I have a relationship with somebody that is going to help me make decisions about my medical care or my finances or whatever. We can do that just informally, or what we did in Texas in the legislature was we passed the Supported Decision-Making Agreement Act. And a supported decision-making agreement is a document that is between the individual with a disability and their supporter, and it lays out the expectations for both people. The reason that we opted to put a supported decision-making act agreement into law is not for the individual with a disability and their supporter as much as it is for other people. Because this document, this agreement that my supporter and I sign, tells other people, third parties, about the relationship that we have together. For example, because we have a supported decision-making agreement, when my son goes to the doctor, the nurse and the doctor aren't necessarily wondering why my 20-year-old son has his old father in the examining room with him, because they've got a copy of his agreement that says that I'm there to assist him to make decisions about his medical care. So that's the purpose of this agreement. And
Chuck, can I just point out that that has been, obviously when supported decision-making legislation passed in Texas, we had never even heard of, coronavirus or had any idea what was coming in 2020. But it's been extra helpful, I guess, for lack of a better phrase, during COVID, to have something like the supported decision-making agreement to help individuals with disabilities who may end up having contracting COVID and needing that support. It was kind of that extra layer of protection to have supported decision-making agreement for a parent or a friend to be able to go with them to the hospital. I mean, obviously, Jeff and I know that there have been issues even with that, but it was
absolutely
a much better situation than nothing.
No, good point, and something that we didn't contemplate when we were thought about this. For some reason, we weren't thinking about global pandemics at the time, but stuff happens. So just real quickly, who can use supported decision-making in Texas? Well, the law says anyone that's 18 or older, so an adult, that has a mental or physical impairment that substantially limits one or more life activities. So the Section 504 ADA version of disability is who we're talking about. So the other big question about supported decision-making is, what capacity does someone need to have in order to use a supported decision-making agreement? And the legal answer to that question is, we don't know. We don't know because the law's silent. We didn't want to tie the use of a supported decision-making agreement to an IQ score or an adaptive behavior score. We wanted to make it as broad and usable as possible. However, an individual really does need to be able to understand that there's a decision to be made and that someone is going to help them make that decision, and they have to be able to communicate what their choices are. Communication doesn't have to be verbal, but there's got to be some way to communicate. And if someone really can't do those things, then supported decision-making probably isn't appropriate for them. Was there a question or something? I heard noises.
No, someone was entering.
Oh, okay.
Yes, so I let them in.
Great. So who can be a supporter? The law says any adult. Any adult in Texas can be a supporter. There's no limits on that. Typically, though, it's going to be someone that the individual with a disability knows, trusts, and can communicate with. So it's oftentimes a close friend or a family member, but it could be lots of other people as well. Supported decision-making is voluntary. It is between the individual with a disability and their supporter to the decision to use supported decision-making. It's not ordered by a court. Once you enter a supported decision-making agreement, you don't have to file that with the court. It's just something that people decide to do on their own. One big thing to remember, because it's really important, and sometimes people get a little confused, a supported decision-making agreement is not a power of attorney. What's the difference? Well, in a power of attorney, I give you authority to act on my behalf. With a supported decision-making situation, I give you the right to help me act. The big difference between a supported decision-making agreement and a power of attorney is who gets to make the decision. And with the power of attorney, we both get to make decisions, but with supported decision-making, only the person with the disability gets to make the final determination. Excuse me.
And we have a question. The parent noticed that these cover more decisions about health, but how about a case of law that was, in a case of law that was broken? And it's interesting, when I read it, I thought I understood what it meant. So to the person who asked me that question, could you explain that a little bit more and direct message me? Because Jeff, I'm not sure you understand what I'm asking. Yeah, it says, I noticed that these cover more.
I have a good guess, but the person who asked the question, if they would rather private message it to Judy, just say yes or no. But I'm wondering if they're referring to, like, for example, if Jeff is my child with disabilities and he breaks the law, is there anything I could have had, like guardianship or power of attorney, to protect Jeff in this situation that he breaks a law? Okay. That's how I hear it, but tell me if I'm
okay. I'm waiting for an answer back.
Oh, I can answer. My kids are running around. Yes, I must when I asked the question. I'm just kind of wondering. I know in the system, a lot of times there are a lot of people with disabilities that's ID or have other disabilities. My concern is I noticed that a lot of these laws protect, decision making and health issues. But what happens, for example, if an adult makes a poor decision, and let's say they're driving and they don't understand what the officer's asking for, or like my son, he would stim. Like if anyone from authority would stim, and he would go back and forth, and someone doesn't understand that. Is there anything like like decision making where they would call the parent and ask them something about the child's condition, or why they're behaving like this? I don't know, or how would we protect them? My concern always is also with law. Is there, as an adult, would this child have protection from a guardian, or from an affected guardian, or a parent?
Great question, Laura.
Look, yeah, it is, because I mean, and it's a very important issue. So if you have a situation where someone that has a disability is involved with the criminal justice system, number one, the first thing that needs to happen is a competent attorney that understands disability issues needs to be involved. But secondly is the issue of support with decision making. And a supported decision making agreement can be used, at least in theory, in the criminal justice system or in the civil court system, because it is an accommodation that an individual with a disability could use or may need under the Americans with Disabilities Act. So there should be a federal right to use your supporter. If you have a supported decision-making agreement, use your supporter in court. It's funny that you bring that up. One of the things that we are currently in the process of during the legislative session is we have introduced a bill that would make it explicit that courts cannot deny someone the right to use their supporter in a court context, and that the presence of that supporter will not do anything to jeopardize the attorney-client privilege. That the supporter is a privileged individual just like the attorney, so they can't be forced to reveal confidences and those sorts of things. So it's been filed. We're working the system, and hopefully by the end of session, this will be explicit that everybody has the right to have a supporter through a supported decision-making agreement with them when they're involved in court or the criminal justice system. Hopefully that answered the question.
Did that answer your question, Laura?
Yes, thank you. I'm just always concerned about my son. He's in middle school, and so a teacher that he wasn't familiar with had asked him, it was something basic, to come inside. He didn't know this person of authority. He started stimming, walking back and forth, not running from him, but just kind of avoiding him. They asked him to come inside. He was held to go inside, helped to come inside. He was held by hand. And he got upset. He went underneath the table. He started throwing things. And I always think, what would have happened if this was as an adult? I mean, luckily they caught me, and I was able to go in there and help him. But what would have happened if he was an adult, without his mom around? Because the reality is he's not always going to have me around. Is there something that would help make decisions, or help him understand what was going on, or to speak for him, that would protect him, because nobody understands him the way I understand the reason why he reacts the way he reacts. And so Laura, that's the reason I was wondering, as an adult, how does that change? Thank you.
Yeah, you're spot on.
Exactly.
And I must tell you, and Jeff and Ginger, I need to connect with you at some point next week, because, and this is to everyone on this call, I am, as I mentioned, not a co-guardian, but very actively involved in a young man's life, and he was arrested, never should have been arrested, spent the night in jail, never should have spent the night in jail. I went to go pick him up at the Harris County Jail. I had to go through so many hoops to make sure they just didn't release him on the street, because what is he going to do? The last thing we want him doing is walking downtown. And fortunately, I knew some people because of my connections. And but when I went to court with him, it was like I had no say when I am actively involved in this person's life. I know him better than the attorney that was just assigned to him 3 minutes ago. So I would love to help you on that in any way that I can. Because firsthand, I have seen the agony that the grandparents, who are the co-guardians, went through. They couldn't go to the courthouse. It was in the middle of COVID. They're in their 80s. I mean, yeah, it was a nightmare. So very, very important.
I think this is going to be a great segue to what I'm
going to you need to contact your legislators. Yeah.
Well, and similar, you know, I'll talk about the bill Jeff mentioned. Well, not a lot because Jeff covered it really well, but I think it's also this, what you're talking about, Laura, is a much bigger systemic issue than guardianship or alternatives to guardianship.
Absolutely.
It shouldn't be on the individual with the disability to have someone to come and help intervene in these situations. Yes, a supporter is great, and we know that that is what people with disabilities oftentimes need to help them understand and communicate, but it also relies on the officers, the judges, the attorneys, the jailers. They also need appropriate training, which is
Absolutely.
a lot more complicated than it sounds. And so the ARC of Texas does not only are we working on a lot of bills to change policy and create some systemic change, we also run a program called Access Justice, where we try and not only train the appropriate people within law enforcement, legal services, victim services, but also bring them together to connect and identify barriers and solutions in local communities, because it is an issue for a lot of people, and it is bigger than just guardianship or alternatives. So thank you for bringing that up.
You are right, Ginger. You are so right.
It is a huge issue. But just real quick to try to finish this out.
Well,
so we can
I do want to recognize Lionella, if I said your name wrong, I apologize, but she raised her hand.
Oh, okay.
When you mentioned like individuals who end up in facilities in a situation like that, let's say a parent didn't have the decision making in place or the guardianship in place, and the person does end up in a jail facility, are you able to implement this, like go to court and put this in place while the individual is in this facility?
You should be able to support a supported decision-making agreement.
Jeff, hold on. First off, I want to make the distinction that you don't have to go to court to get a supported decision-making agreement. So you never have to go to court for a supported decision-making agreement. You can either have two witnesses or a notary. So just because you mentioned, can you then go to court and get this in place? Well, you never have to go to court for SDMA. Sorry, go on.
Exactly right. Well, but she said, or she was also trying to put an SDMA or a guardianship in place. You would go to court for guardianship. So what I was going to say is, you probably aren't going to enact guardianship while someone's waiting in court for their trial, but you would be able probably to execute a supported decision-making agreement. My guess is the best place to start there, once again, is with an attorney that understands these things, because what you're really asking for, aside from, we have a specific law in Texas around supported decision-making agreements, but what you're asking for is an accommodation under the Americans with Disabilities Act to have someone help the individual with a disability be able to understand the process and communicate to other people. And that is something that, regardless of whether you have a piece of paper in place or not, is a valid, is a reasonable accommodation request under the ADA. It would just need to be framed that way. And just for what it's worth, hopefully no one's ever in a situation where they have to think about those things. But if you're ever in a situation where you know someone that has support needs, that's in the criminal justice system and doesn't seem to be getting the kind of support they need, you can always contact Disability Rights Texas, because that's one of the things that we do look at. And we do have attorneys and advocates that can help criminal attorneys in that situation get the kind of accommodations in place that an individual might need. So
that's really helpful, really, really helpful to me, because I am currently facing something like that. And it's really hard for me because I feel like the attorney is not aware of these things. Like I mentioned this, I mentioned the decision maker, and she's like, whoa, it's gonna take time. We have to go to court. And even you mentioning you don't have to go to court.
No.
So I think it does fall within what you mentioned, a lawyer that has experience with disability and knows, because I feel like she's not aware of a lot of things that I mentioned. And it's not that she will like just ignore me, but she's kind of like, no, or no, I don't really know what you're talking about. So it prolongs the situation so long for that person.
Yeah, it's difficult, and lots of attorneys aren't aware. And I know the ARC's trying to train as many people as they can, but they can't get to everybody right away. So if you got a specific issue going on, my contact information is at the back of this presentation. Send me an email or give me a call, and let's talk about to see if there's ways that Disability Rights Texas might be able to help out. So just in the interest of time, there's lots of things that a supporter can do to help the individual with a disability. You know, understanding the decision and getting information are really important, and those things we think about. It was raised earlier, but helping the individual with a disability communicate their decision to other people is another really important thing that a supporter does. Confidential information should stay confidential. A supported decision-making agreement ends whenever the parties want it to end, or automatically it ends if the supporter is ever found either by DPS or DFPS or the criminal justice system to have abused, neglected, or exploited the individual with a disability. As Ginger said, to execute a supported decision-making agreement in Texas, you have a form. There is a form in statute that you can use or something similar to that, or Disability Rights Texas has developed a more simplified, still not completely simple, but a simplified version of that statutory form that people can use for a supported decision-making agreement. It's available on the Disability Rights Texas website, and it's really fairly straightforward the way that it gets filled out. And then it's signed, as Ginger said, it's signed by the parties. And then you can have two people that are 14 years old or older witness it. Why it's 14, I don't know, it just is. Or you can have a notary witness it and sign it, and then it's in effect. And there's an obligation to report. If I know of somebody that's using a supported decision-making arrangement and the supporter I suspect is abusing, neglecting, or exploiting the person, I have an obligation to contact the Department of Family and Protective Services. And yes, supported decision-making agreements can be used with other alternatives to guardianship. One of the biggest examples I can cite is a medical power of attorney. We do a lot of those along with a supported decision-making agreement, just in case there's ever a situation where the medical provider doesn't think the individual with a disability can give informed consent. They have a backup of the other thing. And finally, I mean, supported decision-making, and I know we're going through this quickly, but just to end here, supported decision-making is a lot harder in some ways than guardianship, because if I'm the guardian, I don't have to think about anything else other than what I think is best. And hopefully I'm listening to the wishes of the person under guardianship. But to be truthful, I really don't have to. In a supported decision-making arrangement, I'm actually actively trying to help an individual with a disability understand the decision that there is to be made, understand what different possibilities there are, come to whatever decision they want to reach, and then make sure other people understand what that is and why. So there's a lot more thought and time oftentimes invested there. But I think it's worth it, because I think the result is that you have someone, and where'd we start? someone that's practicing self-determination as opposed to someone whose life is being controlled for them. So I think I will stop there. And thank you. I think we should take a break.
I think so too. Jeff, I can't thank you enough. That was just incredible. And for those of you who asked questions, wrote comments, this is what makes these trainings so meaningful, so important, because we learn from each other. And when you share your personal stories or your thoughts, it makes all the difference in the world. For those of you who have to leave, please make sure you fill out the survey. The advocacy documenting form that I sent to everyone, and a couple of you have already sent it back. Thank you so much. The Texas Council for Developmental Disabilities, they have graciously funded this program. And so in the sessions that you have learned, they're just asking, you know, what have you shared with others? Was it through email? Was it through phone? Was it through social media? So just complete the form and email it back to me. If you don't have a scanner or don't know how to email it back to me, you can take a picture of it and text it to me. My cell phone was in the signature line. So whatever is easiest for you. But I do need that advocacy documenting form back. It could be, maybe you only talked to one person about one subject. Maybe it was for 30 minutes. That's okay. Maybe you, in your line of work, talk about this all day long, and that's great too. So please do fill out the form. We are going to take a 10-minute break, and then we will return. So I have 10:59, so let's just say it's 11 o'clock. We're going to return at 11:10, and I urge you to come back, because what Ginger and Jeff are going to talk about, you know, we all want change. We all want the best for ourselves. For those of you who are self-advocates on this Zoom call, for those of you who are parents of loved ones, for those of you who are community members, we all want the best life possible. How do you make change happen? You've got to contact your legislature. You've got to reach out to your legislators. You've got to share your story. And how do you do that? That's what Ginger and Jeff are going to explain next.
Okay.
Yes. So we will return in about 10 minutes. Thank you so much.